Hello and welcome to Independence Institute Television. I'm your host, Justin Longo, and with me in the studio is Professor Rob Natelson. And today we're going to be talking about a recent Supreme Court decision on Arizona State Legislature versus Arizona Independent Redistricting Commission, of which we will refer to from now on as Arizona, because that's a long case title. This Arizona decision not only has Rob cited in this decision by the Supreme Court, but also has broader implications for Colorado. So before we get into either of those two things, we're going to have Rob give us the background of this case, of which we will call Arizona. Rob, can you give us the background on Arizona?
Sure. For many years, the Arizona legislature had been drawing legislative districts to suit itself. So they would draw their own districts, and they would draw districts for the state's congressmen in certain ways, generally to favor the majority party. So the voters eventually tired of this, and they passed a constitutional amendment in Arizona which said that from now on, redistricting is going to be handed over to an independent commission. Now, there was no constitutional dispute about the ability of voters to do that with respect to Arizona legislators. That is to say, to have the commission draft the districts in which Arizona legislators ran. However, they also provided that the boundaries of congressional districts would be drafted by this commission. At this point, the Arizona legislature objected. The Arizona legislature pointed to a part of the U.S. Constitution, which is sometimes called the Times, Places, and Manners Clause, sometimes called the Elections Clause. At any rate, it's located in Article 1, Section 4, Clause 1. And it gives to the state legislatures the initial power to determine the time, places, and manners of election for people running for Congress. And that it has traditionally included the right to draw legislative districts. And so the legislature of Arizona says, look, the U.S. Constitution has entrusted that duty to us. It cannot be delegated to some independent commission. And so that's what this case was all about. Whether under the election clause, the people of Arizona could decide that within their state, the boundaries for congressional districts would be drawn by an independent commission rather than by members of the legislature.
And this is important because, as you and I have gone over dozens of times previously in podcasts and videocasts, the words, in this case, the word in the key word here is legislature. Words don't necessarily mean in 2015 what exactly they meant in England in the 16 or 1700s or in America in the founding years. So what did the Supreme Court find, and how does that square with what you think?
The Supreme Court found that there are two separate meanings of legislature used in the Constitution, and the meaning depends upon the specific context. When a state legislature is tasked with the responsibility of, let's say, ratifying a constitutional amendment, or before the adoption of the 17th Amendment, choosing members of the Senate, then the legislature acts as a representative body alone. It's not a legislature exactly per se. It's an assembly meant to register the popular will. But when it drafts election laws for the state, including the drawing of legislative boundaries, it's acting in its legislative capacity. And so the term legislature in Article 1, Section 4, Clause 1, according to the Supreme Court, means the general legislative power of the state.
Now, you've got this incredible background of pouring through the founding documents, learning Latin, everything that you've done. Do you agree with this decision?
Yes, as a matter of fact, I do. And this may come as a surprise to some people watching this, because many conservatives have harshly criticized the opinion, and the opinion was issued by a 5-4 majority, and all the most liberal justices were in the 5. But I think for a number of different reasons, the majority was right. For one thing, if you look at the Constitution, you see that when the Constitution talks about the federal legislature, Congress, they also have the same kind of double meaning. That sometimes the term Congress means the senators and representatives meeting together, as for example in Article 5, the amendment article. At other times, the word Congress means the legislative power of the federal government, which would include, for example, the president and his right to veto. It's used that way in Article 1, Section 8. Secondly, election law at the time of the founding, including the drawing of districts, was done by ordinary legislation. So the presumption would be that the founders wanted to incorporate their practices into the Constitution. It was an election law that was, well, in England, for example, it had to be approved by both houses of Parliament, then be approved by the King. In most states, it was approved by the legislature, but in some states, the governor or a council of revision had a role as well. So the term legislature, I think, does mean, in that context, the general legislative power. In addition, beyond the founding era issue, there are two critical cases, both decided in the early 20th century, that held explicitly that the term legislature in this particular section means the general legislative power of the state.
Is this what you found when you wrote this journal article about? So this is like in your wheelhouse. You've written a published journal article on this exact subject. And before we get into the irony of this journal article that you wrote, what did you find in your article that lends you to believe that they were correct in this?
Well, I was interested in learning more about what the Constitution means when it refers to the time, place, and manner of election. And so what I did is, using 18th century databases, I examined many documents that use those kinds of words in describing election law. I also went to, as I always do, to the debates surrounding the Constitution over this particular clause, which were copious because the clause was a very controversial one. And what I could see was that election laws at that time were in fact adopted by the legislative power, whatever that might happen to be. I also noted the existing precedents from the Supreme Court to the effect that it meant that the term legislature meant the legislative power in this particular context, and not merely the particular legislative assembly. Now let's get to the irony, okay? My article was cited here, and it's, by the way, this is not the first time this has been cited by a Supreme Court justice. It was cited last year by Justice Thomas. But this time it was Justice Roberts, and he did so in his dissent from 4 members of the court. But he didn't cite my article for the particular proposition we're talking about exactly. He cited a portion of my article in which I explain why people argued that the time, place, and manner for choosing members of Congress ought to be decided at the state level rather than at the federal level. So in other words, he's citing this article as background.
Did you not make it clear your finding of the dual meaning of legislature in this journal article? Did Roberts not read the whole thing? I mean, it's kind of weird that despite your agreement with the majority that legislature has this dual meaning, that he cited you for something completely tangential to that.
Well, I didn't feel the need to get into the validity of the dual meaning because, frankly, I thought it was pretty obvious from what I had found. But again, this is not the first time that sometimes an article of mine will be cited by a justice whose conclusion I don't necessarily agree with. Now, probably most times, I do agree with their conclusion. But it happened once before. Justice Thomas cited an article of mine on the necessary and proper clause, and I think he used it correctly, but then he went on, it was a religion case, and he went on to decide the religion case in a way that I wouldn't have been comfortable with based upon my findings in another article. But that's the justice's prerogative. I mean, their job is to build their opinion from the building blocks they think are most appropriate, not necessarily buy into my particular schema.
All right, before we get into how this relates to Colorado, let's do a little recap. There was an independent commission in Arizona that by referendum to the people. The people decided that this independent commission could redistrict.
Mm-hmm.
The legislature didn't like that. It goes to the Supreme Court. Supreme Court says, we agree with the people. We think that the term legislature does not mean literally, strictly just the body. All right.
Not in this case.
Not in this case,
Yeah,
right. So now that we've gotten that out of the way, this has an enormous impact on you think. This has an impact on Colorado. And one of our favorite things, you and I personally and the Independence Institute, the Taxpayer Bill of Rights. So explain the connection between this Arizona ruling and Tabor.
Well, as soon as I read this, I realized the implications for Tabor right away. There's a lot of language in the Arizona case which speaks very positively about the initiative process. It quotes Charles Pinckney, one of our founders, in which he said that both lawmaking by representatives and by the people directly are part of the Republican form of government. And of course, the claim against Tabor is that it violates the part of our Constitution that requires states to have a Republican form of government. In addition, the anti-Tabor plaintiffs are arguing that because they have a few state legislators among their plaintiffs, that as state legislators, those plaintiffs have standing, while the court in the Arizona case certainly granted the Arizona legislature standing. The court went out of its way to distinguish that from a case where you've just got a few legislators involved. Then there's the issue of whether cases that are brought under the Republican form of government clause, like the anti-Tabor litigation, whether they are justiciable, whether courts can hear them. And the traditional answer has been no, they're not. And the court, through Justice Ginsburg, reaffirmed that in the Arizona opinion that while some guarantee clauses, Republican form of government cases, while some guarantee cases or Republican form of government guarantee cases may be justiciable, those involving initiative and referendum like Tabor are not. As if that wasn't enough, the very next day, or I guess the following Monday, that came out on a Friday, the very next Monday, the U.S. Supreme Court issues an order in which they respond to the State Attorney General's request for review. State Attorney General is defending Tabor. They respond to his request for a review, and they say the review is granted, certiorari granted, and the case is sent back down to the United States Court of Appeals, which is told to re-examine its holding in the light of the Arizona redistricting case. So I think the message here is really clear. Now, some folks might say, well, the Arizona legislative redistricting case was decided 5-4. While the majority opinion might be good for you, maybe somebody might flip, Justice Kennedy might flip to the other side. But unfortunately for the challengers to Tabor, the dissents don't hold out much hope for them either. One of the dissents, written by Justice Thomas for himself and Scalia, takes the court to task for not being more deferential to direct democracy. Justice Thomas's complaint is that while the court praises direct democracy, in the Arizona case, it has previously been too hostile to direct democracy, so people who are opposed to Tabor can't take much comfort from that.
Seems like a clear message to me.
Yeah, and then Justice Roberts, in his dissent, says, well, it's okay in a case like this to have a voter referendum on something passed by the legislature. You just can't cut the legislature out entirely the way Arizona did. This is his dissent. But of course, Tabor doesn't cut the legislature out completely. It does exactly what Justice Roberts says is fine, which is to give the voters a veto. And then Justice Scalia, writing for himself, and Justice Thomas, would have denied standing even to the entire Arizona legislature. So it's absolutely certain, I think, as certain as law ever gets, that they would deny standing to just a few legislators who don't represent the entire legislature
and who happen to hate Tabor.
Yeah. So, I mean, I think that it is basically a polite way by which the Supreme Court can say to the 10th Circuit Court of Appeals, look, guys, you sort of missed the obvious before. We restated the obvious in the Arizona case. We want you to dismiss this lawsuit in view of what we've said in the Arizona case.
For our viewers that want to know more about Arizona or more about the elections clause and things like that, where should they go?
Well, for all of my commentary, it appears on constitution.i2i.org, constitution. The letter I, the number 2, the letter I.org. I will say that as of this moment, I don't yet have a blog up on this particular case, but there will be one shortly. And then on the general principles involved, I'd recommend the 3rd edition of my book, The Original Constitution, what it actually said and meant.
3 editions.
3 editions of the book.
The first 2 got sold out.
Yeah, right. And that's available at Amazon.
All right. Well, thank you for watching the Independence Institute television. Make sure to check back with us on IITV's YouTube channel. You can catch Rob and I and many others doing all sorts of different wacky, zany, intellectual things on video. So check us out on IITV.
And this was
YouTube.
wacky, wasn't it?
It's always wacky. So stay tuned.